Hello everybody, welcome back to our CMA classes. This is Soumya Santosh, a CMA finalist, and today we are going to start our new chapter of Insolvency and Bankruptcy Code. So let's start. First of all, we have to find out what was the purpose of making this. Okay, so the purpose of Insolvency and Bankruptcy Code is first of all to consolidate and amend. First of all, to consolidate and amend the law which is relating to the organization and insolvency resolution. Okay, so this was the main purpose of doing, first of all, to consolidate and amend the law which is related to organization and insolvency resolution of three people. First, corporate person, second, partnership firm, and third was the individual. Okay, and the real purpose of doing this was to, first of all, to maximize the value of assets of such people, three people. First of all, they are corporate person, partnership firm, or the individual. Hope so this was clear. Okay, other purpose was to promote the entrepreneurship and to make availability of credits to them, to balance the interest of all stakeholders, and to establish an insolvency and bankruptcy board of India. Okay, so first of all, the purpose of insolvency and bankruptcy was first to consolidate and to amend the law which is relating to the reorganization and insolvency resolution of three people: corporate person, partnership firm, and the individual. Okay, and the main purpose was these. Okay, so let's go for some of the regulatory mechanism as per the Insolvency and Bankruptcy Code 2016 would be based on the following pillars. This is pillars. Okay, so there are the mechanisms of Insolvency and Bankruptcy Code is divided into two parts. First is Insolvency and Bankruptcy Code of India. Okay, and the second is Adjudicating Authority, which is simply known as AA. So the Insolvency and Bankruptcy Code is divided into two parts. First is Insolvency and Bankruptcy Code of India, and the second is Adjudicating Authority. Further, the Insolvency and Bankruptcy Code of India is divided into three parts. So let's go and check out. First is Insolvency Professional Agency, second is Insolvency Professional, and third is Information Utilities. So these are the mechanism of Insolvency and Bankruptcy Code. First of all, they are divided into two parts. First is Insolvency Bankruptcy Code of India, second is AA, which is Adjudicating Authority. Insolvency Bank of India is further divided into three parts: Insolvency Professional Agency, Insolvency Professional, and Information Utilities. Hope so this point was also clear to you. Okay, so let's check what is this insolvency resolution now. As I'm repeating it, insolvency resolution process, insolvency. Let's find out what is the actual meaning of this. Okay, insolvency resolution is the process by which an entity, by which an entity can revived in time bound manner under this code. Corporate insolvency resolution process is provided to overcome the state of insolvency. Under the process of insolvency resolution, possibility to revive the business is assessed, and if such possibility is ruled out, it results into liquidation, which means the winding up of the entity. Hope so this was written in very simple language, so you get my point. Okay, so we have to first find out when is this actually happen, which means I'm telling that is there any limit of default? If so, what is the actual limit? Okay, so section 4 says about the application of part 2 of this code, and which says it shall apply to the matter relating to insolvency and liquidation of the corporate debtor. Okay, where the minimum amount of default is 1 lakh. So at least the default which is made by whom, the corporate debtor, should be of at least 1 lakh. If it is less than that, then of course it's not going to apply. Okay, this chapter is not going to apply there. Insolvency resolution process is not going to apply there. Hope so this point was clear to you. However, the limit could may extend up to some further limit. Okay, but However, the central government may by notification specify the minimum amount of default of higher value which shall not include more than the value of rupees 1 crore. So again, first of all, what I told you, corporate debtor should at least make a default of rupees कितना 1 lakh उतना, ठीक है. But central government may extend the limit, ठीक है, of at least kitna, not more than 1 crore. Hope so this part was also clear. So let's find out who are the person who may initiate corporate insolvency resolution process, which is CIRP. So first of all, there is first financial creditor, ठीक है, second is going to be the operational creditor, and third is going to be the corporate debtor. Yes, of course, itself, the company itself also can go for the initiating of CIRP. Hope so this was clear. So let's find out the meaning of financial creditor and operational creditor now, ठीक है. So the financial creditor means any person to whom a financial debt is owed, ठीक, and include a person to whom such debt has been legally assigned or transferred to. Hope so this part was clear, ठीक है. Directly, which means financial creditor who owns the financial debt. So what about the operational creditor now? Operational creditor means a person to whom the operational debt is owed. Simple. Yes, and includes any other person to whom such debt has been legally assigned, which means operational debtor is the one who own the operational debts. Hope so this part was also clear to you, ठीक है. So there are 3 people under section 6 who can initiate the CIRP. First is financial creditor, second is operational creditor, and third is corporate debtor itself, ठीक है. Where let's go and what I have written, check out, ठीक है. When if corporate debtor commit a default, corporate insolvency resolution process may be initiated in a respect of such corporate debtor by FC, financial creditor, OC, operational creditor, and third CD, the corporate debtor itself. Hope so this part was clear. Now let's go for the section 7, which says the initiation of corporate insolvency resolution process, CIRP, by whom? By the financial creditor. By the financial creditor. Number first person who can initiate this CIRP was FC na. So let's check out the things which are written in the section 7. So first of all, the FC either by itself, ठीक है, can apply this, ठीक है, apply for the application, ठीक है, or by jointly. When it comes to itself, then need not to go with some other person na, ठीक है. So FC is the financial creditor, but he is himself applying for the application, ठीक है. But what about the joint case, ठीक है, let's go and check out. When he comes with applying for jointly, ठीक है, in that case he is going with other financial creditors also, ठीक है, or he is also going with other person who is on behalf of financial creditors, ठीक है. So first of all, the financial creditor can apply itself or with jointly, ठीक है. With jointly means with other financial creditors or the person who was appointed on behalf of financial creditors, ठीक है. But first tell me now, the financial creditor is going to apply where? To the educating authority. Remember I told you one of the mechanism of this process, right, insolvency resolution process was of what? The educating authority, the second part, right, the second, let me go back, ठीक है, ऐसे याद नहीं आएगा ना, ये रहा, ठीक है. Insolvency resolution process code involve the mechanisms. First was insolvency resolution of India, ठीक है, bankruptcy code of India, ठीक है, insolvency bankruptcy code of India. Second was educating authority, ठीक है. So the financial creditor is going to apply this application to whom? To the educating authority, and against whom? Against definitely the company, the corporate debtor. Hope so this point was clear. So let me go for the section 7, which says the financial creditor by itself, ठीक है, हाँ जी, or by jointly, ठीक है, हाँ जी, with financial other financial creditor when it comes to jointly, ठीक है, हाँ जी. Okay, second says about when it comes to jointly, ठीक है, which he is going with other person on behalf of financial creditors who may be notified by the central government, ठीक है, who may be notified by the central government, ठीक है, may file for the CIRP, corporate insolvency resolution process, ठीक है, against the corporate debtor. Hope so this point was clear, ठीक है, before the educating authority, but once the default has occurred, ठीक है. So once the default has been occurred, ठीक है, by the corporate debtor, ठीक है, the financial creditor can apply the application to whom? To the adjudicating authority. Along with application, some are the other document which is to be sent, ठीक है. Let's check out which is to be furnished along with the application, ठीक है. And these are the documents. First of all, record of default with the information utility, ठीक है, with the information utility as may be specified. Second, evidence of default with the information utility. First, record of default, evidence of defaults with the information utility which is specified. Second, the name of resolution professional, ठीक है. Now you are going to get this similar with the mechanism which we already mentioned earlier, ठीक है. The information utility, right, and the resolution professional, ठीक है. Okay, so first of all, the evidence and the default, if it is occurred, ठीक है, then the record and the evidence is of the default, it should be furnished along the application, ठीक है. Other than that, the name of resolution professional should be mentioned, ठीक है. Who is proposed to act as an interim resolution professional, ठीक है, in this process, ठीक है. The name of that professional should also be mentioned here, ठीक है, or any other information which is specified by the board. Okay, hope so this point was also clear. So the financial creditor either by itself or jointly can apply to the adjudicating authority against whom against the corporate debtor once the debt have actually occurred, ठीक है. But there are some documents. First of all, the evidence, the record of the default, ठीक है. Second, the resolution professional name or any other documents which is actually specified by the board, ठीक है. I'll come back to this point later. So first of all, I told you that these people, the financial creditor, operational creditor or the corporate debtor can go and apply to the application of this process, ठीक है, to whom? To the adjudicating authority. Now I tell you in section 7 the financial creditor either itself or jointly can go, ठीक है. इतनी बात समझ में आई? Yes, okay. But the adjudicating authority either can accept the application or reject the application, but within how much time limit? Within the 14 days, within the 14 days of receipt of the application, ठीक है. So the adjudicating authority either going to accept that application or going to reject that application. Hope so this point was also clear, ठीक है. And if they have, the adjudicating authority have rejected the application, in that case it should be, the reason of record should be in it should be in a written. Let me read it. It shall record its reason in writing for the same if it is satisfied actually, ठीक है. So on what basis they are going to accept or reject that application? First of all, if let's talk about the acceptance of the application, the default has actually occurred, ठीक है. The default has actually occurred by whom? The corporate debtor, ठीक है. The corporate debtor is a culprit here first of all, ठीक है. So who has done that default? Definitely the corporate debtor, ठीक है. Second, the application for initiating CI, corporate insolvency process, the corporate insolvency process is completed, ठीक है. So which means second says about the process of what corporate insolvency resolution process should be completed. Third, no disciplinary process are pending against the this is proposed resolution process, which means no actually proceeding is pending, ठीक है, against what? The resolution professional. They propose the name which is given by the professionals, ठीक है, by these company, ठीक है, or the financial creditor or the operational creditor. So no pending is actually no proceeding is pending against them, ठीक है. So what were the things? If the AA is going to accept that application, these thing is to be satisfied. The default has actually occurred by the company, ठीक है, by the corporate debtor, ठीक है. Second says about the process should be completed. Which process? The corporate insolvency process. To initiate that, the corporate insolvency process should be complete. Third, there is no any pending proceeding against whom? Against the proposed resolution professionals, ठीक है. In that case, if these three things are satisfied, in that case A is going to accept that, ठीक है, accept that what? Application. Otherwise the A is not going to accept that application, ठीक है. Hope so this point was clear. If these three are satisfied, ठीक है, then the A is going to accept that application. Otherwise the A is not going to accept, which means reject the application. Is there any time limit by when the A reject the application? Okay, yes. Before rejecting the application, the AA shall give a notice to whom? To the applicant. Okay, to ratify within 7 days the default in his application. Okay, so 7 days would be granted to them. Okay. Now let's come back. Once the AA have accepted the application, the corporate resolution process is going to commence. Okay, these points were I actually left behind, and let me come back and complete it. What I told you, first of all, the financial creditor either by itself or jointly going to give the application to the AA, right? Okay, and by against whom? By the corporate debtor, against corporate debtor. Okay, once the default has actually commenced, has actually done, occurred, but with that the application, the documents is to be sent. First of all, what? The record of default, the evidence of default, along with what? Information utilities, which is specified. Second, the professional's name should be mentioned there, and any other specification which is specified by the board. Once it is done, when it is done, what? These documents along with application is sent to AA. Either A is going to accept or reject. For accepting this and rejection, there is how many time limit? The time limit is going to be 14 days. Hope so this up to this was clear. On what basis the A is going to accept or reject that application? First of all, the default has actually occurred. Second, the process are actually completed. To initiate that corporate insolvency process, that should be completed. Otherwise, the application is going to reject. We have to come with if the conditions are satisfied. In that case, the application is going to accept. Otherwise, it's going to, yes, vice versa, it's going to reject. So first, the default has actually incurred. In that case, application accepted. Otherwise, it's going to reject. Second, the process to initiate that the corporate insolvency process is actually, yes, completed. Otherwise, it's going to accept. Otherwise, it's going to reject. Hope so this point was clear. And the proceeding, there is no any pending proceeding against whom? The proposed resolution professionals. If there is no pending, in that case the A is going to accept. Otherwise, it's going to reject. Hope so this point was clear. Once the application is actually accepted by the AA, what is going to happen? The commencement of corporate resolution process is going to happen. It's going to commence from the date of admission of application of the AA. Hope so this point was also clear to you. Let's go for the other point of section 8, which says the Section 7 was of financial creditors. Let's go for the operational creditor of section 8. Which is saying, on occurrence of default, an operational creditor may deliver a demand notice to corporate debtor. What I told you here, the corporate operational creditor cannot go to file the application to adjudicating authority directly. So first of all, what they have to give? They have to give the demand notice to the corporate debtor first of all. In case of operational creditor, they have to give the demand notice to whom? To the corporate debtor. But what was about in case of financial creditor? Is there anything? No. In their case, they can directly apply application to whom? To the A. Hope so this point was clear. So on occurrence of default, operational creditor may deliver a demand notice to whom? To the corporate debtor. The demand notice shall comply with copy of invoice. Along with that demand notice, they have to send this first copy of invoice, demand requiring payment of amount involved in the default. Which means the payment. Third says about the notice shall be in prescribed manner. So first of all, copy of, along with that demand notice, copy of invoice, payment, and third, prescribed manner. The notice is to be in prescribed manner. Which notice? These demand notice, along with demand notice, these things is to be furnished properly to the corporate debtor by the operational creditor. Hope so this point was also clear. So the corporate debtor within a period of 10 days of receipt, what? The notice, but what? The demand notice. Within period of 10 days of receipt of demand notice, bring to the notice of the operational creditor, which means the corporate debtor have to give a reply within 10 days of receipt of demand notice. Hope so this point was clear. Now which says about the existence of dispute, and second point says about payment of unpaid operational debtor. Let me cover let me say it again. This is the continuation part of this, which says if the corporate debtor have to reply within 10 days of demand notice, ठीक है, but what existence of the dispute, ठीक है, if any proceeding is filed before the receipt of such notice of issue or the invoice or the payment of unpaid operational debtor by sending the attest copy of the record of electronic transfer of the unpaid amount from the bank account of the corporate debt, and second is by sending an attested copy of record that the operational creditor has encashed a check issued by the corporate debtor, ठीक है. So these are the actual point. Now section, let's go for the section 9. Section 7 was of financial creditor, ठीक है. Section 8 was of operational creditor. Let's check out now. Section 9 is actually the further process which is involved by the operational creditor, ठीक है. So in section 8 what we read, the operational creditor is going to give the demand notice to whom? To the corporate debtor. Three things: invoice, payment and the prescribed manner, ठीक है. Notice should be sent in prescribed manner, ठीक है. Within 10 days of receiving the demand notice, the corporate debtor have to furnish the details, ठीक है. Once that process is done, let's go for the further process involved, ठीक है, which is in section 9. So the application for initiation of corporate insolvency resolution process by whom? By the operational creditor under section 9, ठीक है, is the continuation of section 8, ठीक है. Hope so this point was clear. So filing an application before educating authority initiating insolvency, corporate insolvency resolution process from that expiry, which date, which expiry, that 10 days expiry, ठीक है, date of delivery of notice and invoice, ठीक है, demanding payment under section 8, ठीक है, from that 10 days, ठीक है, from the expiry of that 10 days, ठीक है, of demand notice, receipt of demand of receipt of what? Demand notice, ठीक है. If operational creditor do not receive the payment, which is actually mentioned in section 8, ठीक है, if the operational creditor do not receive any payment, in that case corporate debtor, ठीक है, against whom? Against the corporate debtor, ठीक है, they haven't received any payment, ठीक है. In that case they can now go for filing of application to whom? To definitely educating authority, ठीक है, before the educating authority. So now the operational creditor can go for to file the application to whom? The educating authority. Hope so this point was also clear. For what? For initiating the corporate insolvency resolution process, ठीक है. So first of all they have to, before applying to the application to whom? To educating authority, they have to inform the corporate debtor, ठीक है. Mr. Look at the default which you have done, you have to make the payment, they have to make the request to the corporate debtor first of all, ठीक है. Once they are done with requesting, ठीक है, now they can directly apply to the boss, ठीक है. Who is the boss here? The educating authority is boss here, ठीक है. So hope so this point was clear. From the expiry of the receipt of what? The demand notice, ठीक है, date of delivery of notice and invoice under section 8, demanding payment under section 8, if OC operational creditor do not receive any payment, ठीक है, by whom? By the corporate debtor, can go and file the application to whom? The educating authority, and to initiate what? Corporate insolvency resolution process. Hope so this point was also clear, ठीक है. Let's go for, along with in section 7 we read that financial creditor have to file some other documents along with the application. Same is going to apply here, ठीक है. So copy of invoice or demand which was sent under section 8 by whom? By the financial operational creditor, ठीक है, is to be, copy of invoice is to be sent along with the documents, ठीक है, application, ठीक है. Second, affidavit that no notice stating existence of any dispute received from the corporate debtor. Third, a copy of certificate from the financial institution confirming that the debt has not actually paid. By whom? By the corporate debtors to the operational creditors, ठीक है. Name of proposed IRP, insolvency resolution process, or any other proof which is actually asked by the board, ठीक है. So hope so this is also clear to you. These are the other documents which is to be furnished along with the application, copy of invoice under section 8 and all, ठीक है. Second, the similar points, right? Remember the name of insolvency resolution professionals, ठीक है. Third, any other point which were actually specified by the board, ठीक है. And one more, this is the affidavit, ठीक है, which is to be sent along with that. And one more thing, the financial institution confirmation is also sent. It is to be furnished here also, ठीक है. In that case, in case of financial creditor, need not to do this, ठीक है. Hope so this part was clear to you, ठीक है. So now these documents is to be furnished along with the application to whom? To the adjudicating authority. Now adjudicating authority either going to accept or going to reject. Remember, this is the same process involved under section 7, okay? So under section 9, this is the same thing which is going to happen, but on what basis they are going to accept and reject that application. First of all, the application for initiating CIRP is completed. If it is completed, then accept, ठीक है. If it is not completed, then rejected by A. Second, there is no payment of the unpaid operational debt. If it is so, ठीक है, then it's going to accept. If there is payment made by, ठीक है, corporate, sorry for the disturbance guys, ठीक है, ignore. Let's continue. If there is actually payment made by the corporate debtor, in that case the A is going to reject the application, ठीक है. Hope so this point was also clear, ठीक है. Notice invoice for payment to the CD corporate debtor has delivered by OC. If it is notice is delivered to the corporate debtor, in that case this application is going to accept, otherwise it's going to reject, ठीक है. No notice of dispute has been received, ठीक है. In that case again accepted, other going to reject. And no disciplinary proceeding pending against the resolution professional proposed by OC, ठीक है. This is again the most common and similar points which we already discussed, ठीक है. So I'm not focusing here, ठीक है. Hope so this point was clear. And again the same note is here, repeating here, which saying that before rejecting the application by the AO shall give a notice to application to ratify within 7 days the default in the application. Hope so you get my point. So majorly we cover section first of all, remember section 4 where the default should be at least minimum how much amount, 1 lakh, ठीक है, maximum 1 crore, ठीक है, CG is going to grant there, ठीक है. फिर section 7, section 8 and section 9 we covered here, ठीक है. Application by whom? There were 3 people: financial creditor, operational and the corporate debtor itself, ठीक है. So these were the process which is involved in CIRP, ठीक है. Hope so you get my point. We'll continue the other remaining portions, remaining section in our next lectures, ठीक है. So till then stay tuned guys, like my video, if it was useful to you, ठीक है. In that case you have to hit a like button, subscribe my channel.